They call them agents or brokers.
Hi, guys. We got about 2 more minutes, okay?
You have any showings today?
I was out yesterday, and while I was showing, I was on the phone with a broker in California that I'm doing business with right now, and he was shocked that I was out showing. They're not allowed to show. And I said, oh, I said, so I expect that to happen up here. And you probably saw the last release about 40 minutes ago from WR. So, yeah.
I missed that one. What'd they say in that release?
Yeah, so it should be in your inbox. That it looks like, I hate to say anything, you know, but it's a good release. There's a lot of information in there, and bottom line, it sounds like we have about another day or two, and then we're not going to be able to physically show properties. Home inspections are not going to be able to occur. However, that really could change, because at WR, there's 2 people on staff that basically live at Capitol Hill. And they probably did not even make it home last night, is my guess. And this seems to change every day. So I'm optimistic that they, meaning WR, are going to be able to communicate successfully that we can do what we need to do in a socially distant, compliant manner. So that's where we're at now.
Oh, good.
Yeah. Crazy. All right. I got 10 o'clock, and let me make sure my phone there. Okay. All right, you guys. So financing addendum, Form 22A. Anything that we need to touch on for any of you that were here the last 3 or 4 days I've been doing this? Okay. Oh, and I found out there's a way, and this morning I was working on finding out how to accomplish that, to get classes approved to deliver via Zoom. So my goal is to get this purchase and sales agreement class and my biggest bloopers and blunders class clock hour approved to deliver via Zoom. And then, you know, while we're still in this state of madness, I'll deliver it complimentary. I mean, that's the least I can do. So I'm going to work on getting it clock houred, and then I can deliver clock hours this way for people. Okay, so Form 22A, the financing addendum. And with the financing addendum, if you have a cash buyer, and we talked about a cash buyer some point in the past, a cash buyer, that means you have to then start asking questions, because buyers think if I have money in my 401k or I'm getting money from a family member that I'm cash, and you're not cash in that case. So if we truly have a cash buyer, we do not use a Form 22A, okay? We have brokers who do that, but that's wrong. And again, remember that one of our requirements is held to the standard and care of an attorney. And that is also selecting and using the correct forms. And 22A is not the correct form with a cash buyer. Well, what if my cash buyer wants to have an appraisal done? That's great. We have the 22AA, that is essentially paragraph 7 from the 22A, copied and pasted onto an AA. So a cash buyer can then use a 22AA, an appraisal addendum, and they can then have the protection and ability to do an appraisal and still be a cash buyer. So, but a cash buyer, don't use a 22A. Don't do it. So starting with paragraph 1, let's see here if I can. Okay, good morning. I'm going to leave the chat box open, and I'm also going to find out, I was on a Zoom call yesterday with Washington Realtors, and I know it's probably simple, you guys, but this is still kind of new to me, to where I can display an addendum on the screen and we can talk about it. I know there's a way to do that, and it's probably really easy. So I expect that to start happening. So paragraph 1 in the 22A. Oh, thank you. Thank you, Adriana. Loan application. The agreement is contingent on buyer obtaining the following type of loan or loans to purchase the property. So it says loan or loans, which means we can check more than one box, okay? We can check more than one box, and we go through the types of loans. And then as we talked about yesterday, there's the other box, and I have in there the Washington bond loan, the down payment assistance, which we'll touch on again here in a minute. So we can check more than one box. And then line 9 is where we indicate what the buyer is putting down. And as I said yesterday, whatever you put in there, and if you make no further disclosures, that means the buyer has that money. It's liquid. So if I put 20%, 10%, or if I put $10,000 or $15,000 down and no other disclosures, I have that money. I have it. It's non-contingent funds. So back to yesterday's class, if that amount is the down payment assistance, which is contingent, that's a loan, you have to now disclose that that's a loan. And that could be done, as we said yesterday, on the 22A, the 34, or the 22EF, evidence of funds. Whichever form you use, you just have to disclose it if it's contingent. So we put the money down, buyer shall pay. Here's where I put my down payment. Buyer shall make application for the loan or loans to pay the balance within 5 days. Now, a note on the defaults. So for example, 5 days is the default here. The Form 35, 10 days is the default, 5 days for a secondary, 3 days for seller response, 3 day for buyer reply period deadline. Those are defaults. If you want the default, write it in. Don't leave the line blank, which we do. But by leaving the line blank, that could set you up for failure, because when something goes sideways, who is the first person that gets thrown under the bus? Us. We do. So I'm going to write the defaults in, because that will then show that we had meaningful conversation with our buyer. Because otherwise, if something goes sideways, you can expect a buyer to not hold themselves accountable, instead throw you under the bus and say, I didn't know that. We never talked about that. So by filling in the default line, 5 days, 10 days, whatever, that helps to show, no, we had meaningful conversation, buyer, and you chose 5 days. We wrote it in. Versus it's blank. Ken, you forgot. We didn't talk about that. So write in, if you want the default, write it in, okay? So 5 days to make loan application. For the purposes of this addendum, now application is defined. And we're gonna see later that that's important, because if buyer then cannot get a loan after a good faith effort, as we will see in paragraph 5 later, we need to establish to seller that buyer made their application in 5 days, had sufficient funds to close, all these things that we're going to talk about. And so if we say 5 days and buyer made application in 6 days or more, that could be considered a default, and seller could be entitled to earnest money if the buyer cannot later perform. So those are important figures. Now, there are instances where the buyer may end up waiving the financing contingency, and it would, in most cases, be unintentional. So paragraph 1B talks about those situations. The waiver of financing in 1B, if buyer fails to make application within the agreed time, say 5 days, changes the type of loan at any time without seller's written consent, or changes the lender without seller's prior written consent after the agreed upon time for financing expires, then the financing contingency shall be deemed waived. But here's what comes up a lot is, let's say I submit an offer to you, and with the offer, I have a pre-approval letter from ABC lender. Well, we have mutual acceptance, and then 2 days in, a friend calls me or my buyer shopping around and switches lenders, and now we're with lender 123. We switch lenders on day 2. Is that a default? I didn't get seller's permission. No, it's not. And people get confused over this. And the reason it's not is I did it within 5 days. I can switch lenders 20 times within those 5 days. It's after day 5 that I need to get seller's permission. Now, loan type, if I have just conventional checked, I can't switch loan types without seller's permission. Okay, so the difference, lender versus loan type. Now, if I have conventional and VA checked, I can go back and forth there. I don't need seller's permission. Seller already approved that. But within that 5 days, I can make those changes as long as I have different loan types checked. I can do that, okay? Because, you know, these buyers, I mean, my buyers now, which I guess we're going to be on a 2-week waiting period, they're all over the place with lenders. I'm trying to focus them in on one lender, but regardless, within 5 days, we can switch around lenders. It's just after 5 days, we need seller's permission. And most oftentimes, this happens anyways, and the transaction closes, and no issue, right? It's if the transaction doesn't close, and the listing agent sniffs out that the buyer switched lenders or loan types or something outside of 5 days, that's where the buyer's going to have an issue. Okay. And then the last line, line 19 in 1B, buyer's waiver of financing under this paragraph also waives paragraph 7, which is the appraisal paragraph. If the appraisal comes in low, buyer can serve a notice of low appraisal, and then buyer and seller can figure out what they want to do. That's gone too if we waive financing under 1B. So that could be a big deal. Now, paragraphs 2 and 3, you guys, paragraphs 2 and 3 were born about, maybe 6 or 7 years ago. And there's still quite a bit of confusion on paragraphs 2 and 3. And there's also, and we also need to get better listing agents at how we implement paragraphs 2 and 3. So we're going to talk about that. Paragraph 2 first. Here's kind of the nutshell version of paragraph 2, then we'll dig in a little bit. So 2A, seller's request for loan information. So again, if I want 10 days, I'm going to write 10 days in there. Yeah. Sorry, guys. That phone never rings. Seller's request for loan information. 10 days after mutual acceptance, seller may give notice requesting information related to the loan application. So this is the seller saying, buyer, show me what you've done to get a loan. Are you getting a loan? What are you doing? Show me. And so 10 days after mutual acceptance, seller can serve that notice, and the notice is the 22AL, and that notice then will compel the buyer to show seller what they've done. Well, it should compel them, because buyer then can either decide to comply and deliver that notice, or buyer can say, seller, go pound sand. It's none of your business. I'm not going to comply with you. So 10 days after mutual acceptance, seller says, hey, buyer, what have you done? Show me a loan. My house is off the market. I want to make sure you're doing what you need to, and I want to make sure as best I can that you can buy my house. So then if buyer wants to comply, then 2B says within 3 days after receiving the request, buyer's going to give a notice, and we have that in our forms. It's the 22AP, and it's going to have all the information as to what buyer has done to get a loan. Now, what I also like about the AP is there's language in there because, you know, some lenders, well, I can't disclose that information, it's confidential, and that's okay, because in the AP, it says that if the lender takes that position, buyer will do what's necessary and give lender permission to disclose that information. And the other thing I like about AP is that there's language in the AP that if buyer complies, then that also means just about anybody can check in with lender at any time to do additional checkups to see where buyer's at now in getting the loan. But now if buyer says, hey, go pound sand, I'm not going to show you, it's none of your business. Okay. Paragraph 2C covers that. And 2C says, okay, if buyer doesn't give that information out, then seller may give the right to terminate notice, which is described in the 3rd paragraph. And the right to terminate notice, I usually refer to it as like a 3-day notice, because what that says is, okay, buyer, you're not going to comply. Here's the right to terminate notice, which says, buyer, you either waive financing or I may terminate the contract. And that's after 3 days of serving that notice, 3-day notice. So buyer, if you don't want to comply, that's okay. We have forms for that. And now I can serve you a right to terminate. And if you don't waive financing, I can terminate the contract. If you don't want me to terminate you, you're going to have to waive the financing addendum. That's paragraph 2. I'm going to talk about paragraph 3, and then I'm going to talk about how we need to be better with both those paragraphs. So now paragraph 3, any questions on 2? Okay, paragraph 3, seller's right to terminate notice. So this is using the defaults, which we're going to write in if that's what we want. 30 days after mutual acceptance, seller can give that same 3-day notice that we just talked about. 30 days after mutual acceptance, seller can give that same 3-day notice and say, buyer, if after 3 days, if you have not waived financing, I can terminate the contract. Buyer, if you do not want to be subjected to being terminated, then waive the financing. And look, this is 30 days after mutual acceptance. Can you buy the house or not? I mean, to me, that's very reasonable to have that in there. Now, what'll happen a lot of times is buyer broker, let's say the close date is 30 days out. Buyer broker on paragraph 3, they may write in 45 days, which I get. They're doing their job. They're representing their buyer. I don't get upset. Don't get emotional over it. Just don't get emotional. What that buyer broker is attempting to do is exhaust the seller's opportunity to exercise the rights in this paragraph. And I get that. So when you receive that as a listing agent, the key is to, one, don't get aggressive or defensive or emotional. Take it to your seller and as calmly as I am now, explain what buyer broker's doing. And then explain to seller, here are your options. We can counter at 20 days or counter at anything else, or we can accept it. But here's what they're attempting to do. And seller, what would you like me to do? That's how you handle that. And I get why buyer broker's doing that. So back to paragraph 3, after 30 days, seller can serve that 3-day notice. And buyer, what are you going to do? Are you going to waive financing, or are you going to be subject to being terminated? Seller doesn't have to terminate you, but they can. So that's paragraph 3. Now here's where we're failing. And in a class, I'd ask you to raise your hands and stuff, but I don't see many of you. How many listing agents here are exercising the seller's rights and serving these notices in both paragraph 2 and 3? And like I tell my kids, I already know the answer. And the answer is, we're not very good at serving these notices. So why? Why aren't we serving these notices? Why after day 10 are we not serving the notice per paragraph 2? Why after day 30 are we not serving the notice per paragraph 3? Why? The reason is either you don't know you can, but I think the bigger reason is I don't want to rock the boat. You know, we're going along so well. I don't want to upset you. I don't want to offend you. I don't want to change the tone. I want this to go smoothly. I don't want confrontation. So you're not doing it. Now, when these paragraphs were born, like I said, about 7 years ago, I wasn't too big on doing it either. And Annie Fitzsimmons was, you gotta do it, gotta do it, gotta do it. I'm like, yeah, you're a lawyer. You're not out here selling real estate. You're a lawyer. I get it. Textbook, lawyer answers. I get it. Well, my tune has changed about 4 years ago. So there's been some issues around these paragraphs. So what happened was a broker on the west side of the state, and we're talking about more money on the west side usually than on the east side. The house was, I think, about $800,000, and I think it was about $10,000 maybe or so earnest money. And what happened was the transaction failed, and the broker was the listing broker. And listing broker was contacted by seller's attorney, and seller's attorney asked listing broker to provide evidence that listing broker delivered these notices when listing broker was able to do so. And I don't remember how, but at the time it was shown that had listing broker done this, then damages to the seller would have been mitigated, or it would have made a big difference. I don't remember those details. So listing broker did not serve these notices and essentially wrote a check, I think for the earnest money, to make the seller whole. So that got my attention. And then, as I've said before, over the last 3 or 4 years, with the type of market we've been in, the requirement of being held to the standard and care of an attorney has come up a lot. And so that would relate to these paragraphs. Would an attorney serve these notices in a contract that the attorney drafted? Absolutely. So let's get back to why we aren't doing it. And I've been through about 3 classes with Annie where we talk about this, and in each to where it's easy, it's non-aggressive to serve these notices. And we're not going to role play here. But how that goes is, I see Steve on the call. I'm the list agent. I get an offer from Steve and we sign it around. Hey, Steve, awesome. So glad we're going to work together. And just so you know, per paragraphs 2 and 3 in the financing addendum that you have in your offer, you can expect, so explain to your buyer, you can expect a notice per paragraph 2 and a notice per paragraph 3. It's not because we're posturing or we don't like you or we don't want to do business with you. It's just those paragraphs give us the opportunity to do that. My seller wants me to do that. So I found that if you just set the expectations with your buyer, then it's received as a non-threatening notice. But if we can have that conversation up front, now Steve, buyer broker, expects that, knows that it's coming, and can prep their buyer. And then when it happens, it's not a big deal. But you got to do it. You got to have the conversation up front, set the expectations, but then you also have to make sure in your checklist and your calendar that you stay on top of your time periods and you then generate those notices. Because as we talk about, who decides to use a 22A? The seller or the buyer? It's the buyer. So the buyer elects the financing addendum, and in that addendum are paragraphs 2 and 3. So the buyer is basically saying, here's seller, here's my financing addendum, and with that, I'm giving you the rights contained in paragraph 2 and 3. So why wouldn't we then exercise the rights seller has in paragraphs 2 and 3? The buyer gave us those opportunities. So I think we just need to rethink how we're doing that and raise the bar of professionalism and representation. I think that's a much tighter, much more competent way to represent your seller. But the key is to have that conversation up front with the buyer broker, and you can even one-up it. And I've seen this, and I'm good with it. I've seen in agent remarks, the listing agent will say, expect, and then they outline these forms, expect to receive this and this. So they're already like priming you to like, hey, we're gonna use these forms in the financing addendum. And I just think that's a really professional, competent way to handle it. Plus, look how you are representing your seller, right? Any questions on that? Okay. So paragraph 3, let's spend a little more time on paragraph 3. So 3A, again, that's the 30 days. Here's your, what I call 3-day notice. Buyer, if after 3 days you have not waived financing, seller may, doesn't have to, but may terminate the contract. And then paragraph 3B explains where if you don't waive it, seller can terminate. But I want to look at 3C because 3C is in my bloopers and blunders class. And that is because buyer brokers are skipping 3C. You're not checking a box. And I want you to see that by not checking a box, you are hurting your buyer. So 3C, appraisal less than sales price. What 3C is determining is, and we're just in paragraph 3, nothing else on financing. Just in paragraph 3, seller serves the notice. Buyer says, I don't want to get terminated, so I'm going to waive financing. Per 3C, buyer, did you also waive paragraph 7 or not? And again, paragraph 7 is the appraisal paragraph where, again, if the appraisal comes in low, buyer can serve a notice of low appraisal and buyer and seller can work through it or not work through it, but it protects the buyer. So if I'm going to waive financing per paragraph 3, buyer, do you want to preserve paragraph 7 or do you also want to waive paragraph 7? And I'll read 3C. If you don't check a box, you've waived 7. You've hurt your buyer. So 3C, appraisal less than sales price. Buyer's waiver of the financing contingency under paragraph 3 will or will not constitute waiver of paragraph 7. And it says in parentheses, will if not checked. So you don't check a box, you will waive 7 if you waive financing under paragraph 3. And you're a buyer broker, and I hope now you can see you've just hurt your buyer because now 7's gone. You've removed the safety net. So please slow down and make sure you address paragraph 3. And if buyer makes that decision to, hey, I'm okay. I want it to stand out. I want to get picked in this multiple offer situation. I'm okay if we lose paragraph 7. Then I say, don't leave that blank. Check will. So that helps to show you had meaningful conversation with your buyer. I would also document that conversation, or if it's an email format, whatever, but I would put that conversation in material communications in the transaction file, just in case it comes up where seller serves the notice, buyer waives the financing, also waived paragraph 7, and appraisal comes in low. Now you have the documentation showing, proving that you and buyer had that conversation and buyer chose to waive paragraph 7. Because remember, we're going to get thrown under the bus, and buyers, just like sellers, have amnesia, and it'll be like, we never talked about that. I can't believe you did that to me. I want money now. Oh, and I know a lawyer. Like, how many times do I hear that? So document that conversation, you guys, and more importantly, don't skip 3C, okay? Questions? Okay. So paragraph 4, loan cost provisions. This is one of those paragraphs, like I said on day 1, there are certain things that me as a broker, I'll highlight. I'll put little highlight marks. Paragraph 5, included items on page 1, form 21, I will highlight because I want to make sure I don't sell my seller's refrigerator or washer and dryer like I've done. So I'll highlight things to draw my attention to it, and also to ensure I have that conversation with my client. Paragraph 4 in the financing addendum is one of those examples, because if I'm a listing agent and my seller is contributing 5% to the buyer's costs per paragraph 4, I want to make sure I have that conversation with the seller and the seller understands that and knowingly agrees to it. I don't want to, oops, I forgot, and then we get our closing documents, and what's this extra 5% or $15,000 coming out of my proceeds? Oh, we didn't talk about that? So paragraph 4, and even if it's 0, I'm going to still highlight it because I want to show my seller, look, and they're not asking for anything. But don't forget to talk about paragraph 4, you guys. So loan cost provisions, that's where we would put in the amount of money that's going to be applied to buyers' loans and settlement costs. Now they added on line 52, and this is a good revision, but there's still confusion with it, and even confusion with me because I've talked with lenders and I'm not getting the same answers. So this is when it's really important to talk to the lender that's working with the buyer. But paragraph 52, if checked, buyer shall pay buyer's share of the escrow fee for the VA loan. And then it says, note that VA regs prohibit buyer from paying loan and settlement costs exceeding 1% of the amount of the loan. So, you know, prior to this, if the financing was VA, as a listing agent, you would need to understand what the non-allowables are, the cost that the borrower is not allowed to pay. You would have to find out what those non-allowables are, how much are they, so that you can communicate to your seller, here's what you're going to have to pay towards buyer's loan costs. because buyer can't pay them. That's why they're called non-allowables. So this revision now implies that buyer can pay those costs. But I've talked with different lenders, and like I said, guys, I think the takeaway is that there's options here where buyers can pay some or all of the non-allowables, but don't just go off that. Like if you're in the situation real time, talk to the lender so that you have a clear understanding, because like I said, I'm not getting straight answers from lenders and it's still confusing. And even some of the lenders I talked to were confused. So it's enough to know that there's an ability for buyers to pay some or all of the non-allowables. How much of it, I don't know. That's going to be a conversation with the lender. But this is really key because about 2 or 3 years ago, when it was multiple offer, and a lot of buyer brokers were using those love letters, personal profile letters. My buyer is a single mom with 3 kids, and we just love this house because, blah, 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 right? All the emotions to try to get the seller to pick them, buyer love letters. Well, those were leading to some discrimination claims. And we had one that was brought to us about 2.5 years ago when I was sitting on the board of directors, where a listing firm, they had multiple offers, and one of the offers had a love letter in it. And in the love letter, it was disclosed that buyer was a veteran. Well, seller did not pick that offer. They went with another offer. That buyer became very hot, got a lawyer, and accused the listing firm of discrimination against a protected class, because veteran status is a protected class. And the board of directors are all going, well, yeah, that's a protected class. That's a veteran. You can't discriminate. And I'm like, time out for a second. The seller was discriminating against the loan type, not the individual. And loan types are not protected classes. But regardless, that listing firm, and I have a lot of respect for that DB, that listing firm had to pay money to make that go away. Because as I always say, lawyers know it's cheaper to settle than to prove you're right. And so they had to spend money on that. And so we came out with this big campaign here locally about VA borrowers and VA loans and all the advantages of VA loans, and sellers, we need to consider VA loans, blah, 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 to try to get more sellers to accept VA loans, because sellers, they're rejecting VA offers because what we found out, the listing agents didn't even have an understanding, a good understanding of VA loans. I mean, these non-allowables, you guys, the last one I did, I think the house was about 250-ish or something, 270-ish. And the non-allowables were like $600, maybe $700. But when you ask brokers, hey, well, how much are the non-allowables? Oh, they're like $2,000, $3,000. No, they're not. So we're part of the problem. So this is a good revision because it gives the buyer an opportunity to pay those costs that before sellers just almost automatically we're going to have to pay. Again, please check with the lender and don't quote amounts or anything like that because it's not completely crystal clear, but enough to know that buyers can pay some of those. So, and there's a whole nother thing on love letters that if we have time, if you ask me, I'll tell you how I deal with love letters now. But those are sticky wickets. And, back in like 2006 to 2009, I was a contract trainer for an international real estate company. And I would train around the country. And in the curriculum, I taught love letters. And so it's just interesting to see how that's gone from we teach you how to do these things to now, oh my gosh, there are going to be discrimination cases filed against you, right? So that's paragraph 4. Any questions on 4? And I hope I made sense talking about all of that VA stuff. Okay. So you have to ask questions so I can drink coffee. All right, paragraph 5, you guys. This is the paragraph. This is the paragraph where when you come to me and say, in fact, I have one right now going on. One of our buyer brokers, the client actually showed up unannounced at my office about 4 weeks ago. And usually when someone shows up unannounced, like, okay, I'm getting served. I get it. But I wasn't getting served. He's trying to get his earnest money back. And before I can even try to help you, we need this letter defined in paragraph 5. If after a good faith effort, buyer cannot get a loan, which happens, we want to get this letter. And paragraph 5, earnest money, it says if buyer has not waived financing and cannot get financing after good faith effort, then on buyer's notice, the agreement shall terminate and earnest money shall be refunded to buyer. Okay. Refunded to buyer. This language is peppered throughout our forms. It's in 22B. We just read it in 22A. It is in Form 35R. Earnest money to be refunded to buyer. If you don't understand what it takes for your buyer to get the earnest money back, this language will set you up for failure. Because as we talked about the other day, this language is not enough for the closing company to release the earnest money, right? Because the closing company who's holding the money, or the firm, if the firm's holding the money, if you have a trust account, which we don't, thank you. But who's ever holding the earnest money, they want to see that both buyer and seller have signed off on who gets the money and how much. So you'll set yourself up for failure because you'll have the false sense of security and you'll share that false sense of security with your buyer that they'll get this money if this happens. And then this happens and the closing company won't release the money. And now the crosshairs are on you. Ken, you said, right? So you have to understand what it takes to get earnest money back, and you have to change your language. And I propose that you say something similar to what I say, and it is buyer, you would be entitled to getting your earnest money back. I don't say you're going to get it. I say you're going to be entitled to it, but here's what has to happen for you to actually get it. And I will say that so many times so that if we ever run into a situation, ultimately an earnest money dispute where seller won't release it, the buyer already understands that because I've told them 50 times, because I don't want the crosshairs to land on me, right? I mean, in this business, crosshairs are all over us, right? They're looking for a place to land, always, always. And they're looking to land on us. And so we have to do everything we can to get the crosshairs away from us. Fill in the default time periods. Have these conversations with your buyers. Document these conversations. Put these conversations in material communication. That's how we get these crosshairs. Go away, crosshairs. I don't want them to land on me. That's how we can do that. So back to paragraph 5 with this earnest money. Again, buyers, you're entitled to it, but you're not necessarily going to get it. So the letter, we're going to get this, and I've had to copy and paste this paragraph and send it to the lender and say, this is what we need. So we're going to see the earnest money shall be refunded to buyer after lender confirms in writing. 1, the date buyer's loan application for the property was made. Why? Because remember, page 1, buyer, you said you'd do it in 5 days. Did you? I need to verify that, because if you did it past 5 days, you're in default. So we want to know when you made application, that buyer possessed sufficient funds to close. Did you, or was it contingent on grandma's gift funds that you didn't disclose per paragraph A, form 21? So we want to know you had sufficient funds to close. And why were you unable to get financing? Because remember, buyer has to make a good faith effort. And so a lot of what we see is buyer just becomes non-responsive and is now not getting documentation to the lender in a timely manner. Is that good faith? That doesn't sound like good faith, which reminds me, guys, here's what I started doing a couple years ago with buyers, because it's a hassle getting a loan, right? But fortunately, we're not doing it every day. So I tell my buyer, hey, buyer, to save you from distress, here's a folder. Everything that you end up providing to the lender, put in this folder and set this folder aside, because the lender's gonna later ask you for some of the same stuff. And it's not because the lender has amnesia, it's because the underwriters are now calling for things and now they're coming back to you asking for the same stuff. Now, if you don't put your stuff in this folder, you're gonna start getting exasperated, frustrated, upset. My gosh, I don't know where I put it. We're moving, I got stuff everywhere. But if you have it in this folder, okay, here you go. It's the third time I'm giving it to you, but no problem, here you go. So make sure you have, you set your buyers up that way and essentially set them up for success. So why couldn't you get financing? Oh, the other thing that I want to remind you to have this conversation with the buyer is, buyer, now is not the time to go out to a furniture store and put $7,000 of furniture on credit for the house that you don't own yet. Now is not the time, buyer, to go buy a new car to go in the garage for the home you don't own yet. Don't quit your job. Like, you have to have that conversation, because the lender is gonna check the ratios right up to the last second before they hit the funding button. And I know there's people on this call who've had that experience where all of a sudden the buyer doesn't qualify because they went out and put $7,000 of furniture on credit. So you have to have that conversation. So then once we get that letter, and assuming that buyer has done everything they said they were going to do, now we can make an attempt to try to get seller to sign off on the earnest money. An attempt. And me personally, as a designated broker, I'll make an attempt. I'll put my foot in the water. But if there is a lot of pushback and we're starting to get significant engagement, we have to be careful, because remember what our license allows us to do. We don't want to step into that unauthorized practice of law pool. So I'll send this to the listing agent and say, here's the letter. It has shown that buyers did everything they're supposed to do. They made application in 4 days. They did this, they did that. And seller, by acknowledging the 22A, essentially has already agreed that buyer gets their earnest money. So help me help you. What's the seller hanging their head on now? That's kind of how that conversation goes. And it's always emotions. Which is why seller is resisting releasing the earnest money. And there was a DB one time where the DB was representing the sellers. Turned out to be their kids, his kids, which wasn't disclosed, but that's another class. And the DB kept telling me, well, you know, Ken, my kids just felt like buyers didn't intend to buy the house. They just felt like they weren't making a good faith. It was all this felt stuff, right? And I said, oh, so-and-so, I completely understand that. I completely understand that. Show me in the contract so I can explain to the buyers. If seller feels this way, this is what happens. And I'm like, why am I even having this conversation? I don't care how they feel. It's irrelevant. That's why we have contracts, so we don't have to deal with feelings. And this is a DB justifying seller's resistance to returning the earnest money because of how they feel. So you're going to run into that a lot. And what really frustrates me is then when the listing agent comes back and says, well, Ken, I tell you what, the seller said they'll split it 50-50. tell me, how did the sellers even know that was an option? Were you coaching them? Is this a crime of opportunity? That really fries me because you're almost an accessory, to the crime. And that is a crime of opportunity. That really ticks me off because we have situations where buyer is completely entitled to that. They've done nothing wrong. And sellers are upset and emotional. And that listing agent, well, why don't we just split it? They're not going to want to go to court. That is wrong, wrong, wrong in every book that you can show me. That is wrong. But that is what we deal with earnest money and earnest money disputes, and we deal with enough of them. The other problem with paragraph 5, you guys, is there are some lenders, and I see it mostly with banks, that will not write this letter. They won't disclose this information. And I made it up to like a regional director one time of a bank because they would just generate that kind of a template letter that didn't answer any of these questions. And the regional manager, Greg, said to me, well, Ken, we close, 3,000 loans a month and we've never had a problem. What does that mean? That doesn't mean anything. It's never a problem until it's a problem. And so it really frustrated me. And I said, well, Greg, okay, so your bank, I'm sure then will have your borrowers sign a disclosure which says, hey, in the unlikely event that we can't fund you after good faith effort, it's unlikely you'll receive your earnest money back because we won't generate a letter disclosing and then writing out the points. I said, I know you then do that, Greg, right? Which of course they don't. But the problem there, as you probably figured out, is they are setting their borrower up for failure. Because if borrower then can't get a loan after good faith effort, it's unlikely they're going to get their earnest money back because their lender won't generate this letter that buyer and seller agreed is necessary for buyer to get their money back. So maybe a takeaway there is with your buyer, like my buyers right now, they want to work with Chase, a bank. So I'm going to make sure that Chase, their lender, sees this paragraph and ensures in writing that they'll generate this letter if necessary. Because I just, otherwise these buyers are out there getting hurt. And again, it falls on us, and now they're blaming us and they tell all their friends, how we are, how incompetent we are and how they've been damaged. So that's paragraph 5, you guys. Any questions on that? We have about 10 minutes left. Confirming you'll be done at 11. Yes, I'll be done at 11. Who's ever asked me that? Okay. Yeah, we'll be done at 11. We may not finish this, but we'll be done at 11. Inspection, paragraph 6. Paragraph 7, here is the appraisal paragraph that we've talked about. And remember 3C, are we waiving it or not if buyer waives financing? Paragraph 7, you guys, is a great paragraph to go over with your seller who wants to list their home at an unreasonable price. Paragraph 7 can help you with the seller to get a reasonable price, because with 7, you can show your seller, look, unreasonable seller, even if we list it here, the buyer is likely to be getting a loan. Would you agree? Okay, so in getting a loan, they're going to have an appraisal done. And the appraiser is going to do a lot of the same things, and they're going to see a lot of the same info and data that I have that we've just got done discussing. And so likely that they could come in with a low appraisal, maybe similar to the price I'm suggesting we list at. And now here are your options, unreasonable seller. And when does that happen? That doesn't happen the day after mutual acceptance. So now we're off the market for what, 3 weeks maybe? And that appraisal comes in low. And so let's look, unreasonable seller, at your options. And per paragraph 7, you have the option of either, okay, I'll lower the price to the appraised value, and that may be similar, probably similar to what I'm suggesting we sell your house at. Or, and you know, seller, the other option is really not an option, even though it's still in our forms, and that is where you can have the property reappraised, but you're gonna have to pay for it, and you can't pick the appraiser. It can't be Uncle Eddie who, you know, did an appraisal for you once last year. It has to be an appraiser approved by the lender. Oh, and the lender has to agree that that you can do a reappraisal on the property. An unreasonable seller, I have to tell you that post-recession, lenders, they got their, you know, lunches handed to them, and a lot of things have changed. And where a lot of them, I mean, they don't allow a secondary appraisal now. So that's really not an option, unreasonable seller. So far we can lower to the price that I'm suggesting we sell your house at. Or the other option that was given to us is if the appraisal comes in 20,000 low, we can agree to meet the buyer somewhere in the middle. You know, 10,000, 10,000, and we got it. Or you could just reject the notice of low appraisal and buyer can then leave. Oh, and if that loan type is a government loan type, then, you know, that's going to stick to the house for 6 months. So now we're going to eliminate that section of the buyer pool who are government loan borrowers. So 7 is a good paragraph to use as a tool to get a reasonable list price. Okay, I'll keep going. I see it's 10:54. And really with paragraph 7, what works well with paragraph 7 is to look at the form 22AN, notice of low appraisal. That spells it out really well, what happens when we see a low appraisal. So we'll probably finish 7 here at 10:54. So paragraph 7, it has to start with a notice of low appraisal. Buyer, because buyer, it could come in low and buyer could decide, it came in low, I'll throw an extra whatever to close that gap. Or buyer can choose to serve a notice of low appraisal. So buyer serves a notice of low appraisal. And now, seller, here are your options per 7B, which I just explained to you, right? And then depending on what seller says, the 22AN lays it out nicely how then buyer may respond. So that is paragraph 7. I say it's 10:55. You know what? Let's knock out 22A. We can do it. So paragraph 7, key paragraph, and I hope you start using it with your sellers to get that reasonable list price. And then paragraph 8 talks about the appraisal certificates. They did add a revision with the July 2019 revisions. That's line 104. And it says, seller and buyer shall execute a document setting forth the prior provision or similar provision known as the FHA or VA amendatory clause. You know those amendatory clauses that y'all have to sign? It just documented it that buyer and seller are going to sign that as required per the lender. So that's been added to 22A. Any questions on 22A? And what we'll do is tomorrow I'll start with the 22AD, and then let me see what's after all the financing stuff, just so you can decide if you want to join us or not. Optional clauses, form 22D, will be tomorrow. So I'm going to hang out here. You guys can bail. You guys can ask me questions, but I'll hang out for a few minutes. Yeah, okay. For screen share during a Zoom meeting, hover at the very bottom of the screen. There will be a green folder pop up. Yep, okay, sure. Push that and we'll ask you what screen you want to share. Click on that screen. Okay, so Adrian, so I'll have another screen, say like transaction desk. and I'll have, like in this case, a 22A there, and then I can just switch screens. It sounds like I'll play with that here when I'm done. Thank you. Thank you. Anything else, you guys? Broker questions, doesn't matter to me. I'm here. Feel free to share these classes with people you think would benefit from them or get something out of them. This is just, what I can do in this period of time we're in. It's my way of just helping you guys when we're so limited. I will continue to work. You're welcome, Sue. Thank you for being here. I'll continue to work with the DOL. I think I didn't get any response from the other person. Now I'm going to the head guy to find out how I can get some things clock houred, so at least we can get some hours for our time. So that's what I'll work on. And is there a loan besides VA that is government? FHA loan, considered a government loan. You bet, Russ. Russ, do I still owe you a call? I remembered you called me the other day yesterday when I was showing. I'll call you after this if okay, I'll call you after this, man. Yep, you're welcome. All right, you guys, thanks for being here. And we can still go outside and run too. We can still get our exercise in. That's what I'm going to do after this. All right. Peace.